The defendant sat in an orange jumpsuit. The jury saw chains on his wrists. He hadn't been convicted of anything. But in that moment, his presumption of innocence was already dead. And the Constitution couldn't save it. Here's what nobody tells you about the presumption of innocence. It's not actually in the Constitution. Search every line of that document. You won't find those words anywhere. This principle that Americans believe protects them came from medieval Europe, when accused criminals could prove innocence through trial by ordeal. Boiling water. Hot iron. If you survived, God declared you innocent. We've evolved past torture, but here's the disturbing question this video will answer. Has our modern justice system created new ordeals that destroy innocence before any verdict is read? The answer involves something happening right now in courtrooms across America. And by the end, you'll understand why legal scholars are calling this a constitutional crisis in slow motion. The presumption of innocence became American law through a Supreme Court case in 1895. Coffin v. United States established that every defendant enters court cloaked in innocence. But that cloak has holes. Consider this. Roughly 470,000 people sit in American jails right now awaiting trial. They haven't been convicted. Many can't afford bail. They've lost jobs, homes, custody of children. All while legally innocent. If this is making you see our system differently, drop a like. Because here's the first crack in the presumption. When you jail someone for months before trial because they're poor, you've already punished them. The verdict becomes almost irrelevant. Studies show these pretrial detainees plead guilty at dramatically higher rates. Not because they're guilty. Because they're desperate. Now let me shift your perspective entirely. Imagine you're a prosecutor. You have a defendant you believe is guilty. The evidence is strong but not perfect. What do? Many prosecutors engage in what legal scholars call overcharging. Stack multiple charges. Threaten decades in prison. Then offer a plea deal for a few years. 97% of federal cases end in plea bargains. Think about that for a second. Almost no one goes to trial anymore. The presumption of innocence was designed for trials. It was designed for juries weighing evidence. But when 97% of defendants never see a jury, where does innocence go to be presumed? This isn't a flaw in the system. This is the system. And it's happening because the people who designed constitutional protections never imagined plea bargaining would replace trials entirely. The stakes get even higher when we examine wrongful convictions. The Innocence Project has helped exonerate over 375 wrongfully convicted people. Many spent decades in prison. Each case represents a complete failure of the presumption of innocence. But here's what keeps legal analysts awake at night. For every exoneration, experts estimate dozens more innocent people remain imprisoned. They lack DNA evidence. They lack resources. They lack anyone who believes them. The presumption of innocence was supposed to prevent this. Every defendant should enter court with the full weight of doubt on their side. The prosecution should face an uphill battle. Yet somehow, we've created a system where sitting at the defense table already makes you look guilty. Studies on jury psychology prove this bias exists. And it starts the moment jurors see that defendant. But here's what nobody is talking about. Everything I've just told you. That's just scratching the surface. The real threat to presumption of innocence in 2025 isn't happening in courtrooms at all. It's happening on your phone right now. Social media has created trial by public opinion on a scale our legal system never anticipated. When a high-profile arrest makes headlines, millions form opinions instantly. They share mugshots. They demand justice. They've already decided guilt. Now imagine being selected for that jury. Subscribe if you want to see where this leads. Can you truly presume innocence for someone you've spent months believing was guilty? Defense attorneys are filing more change of venue motions than ever before. But in the age of internet, there's nowhere left to run. The presumption of innocence is drowning in viral content. Let me paint you a picture of how bad this has gotten. In 2023, a federal judge took the extraordinary step of delaying a trial for 18 months because media coverage had so thoroughly poisoned the jury pool. 18 months. A defendant who may be completely innocent, waiting another year and a half for the trial that should prove it. Meanwhile, their life remains suspended. Their reputation destroyed. Their presumption of innocence exists only in legal theory while public opinion has already rendered its verdict. Tell me in the comments. Does this seem like justice to you? And here's the moment that changes everything about how we must approach this crisis. 3 landmark Supreme Court cases are working their way up right now. Cases that could fundamentally redefine what presumption of innocence means in the digital age. And this brings us to the revelation that legal scholars have been quietly warning about. The presumption of innocence was never meant to survive what we've built. It was designed for a world where 12 local citizens heard evidence for the first time in court. Where news traveled slowly. Where a fair trial meant starting fresh. We don't live in that world anymore. Every defendant now faces 3 separate trials. The trial of public opinion. The trial of media coverage. And finally, if their life hasn't already been destroyed, the actual trial in court. The presumption of innocence only applies to one of these. The Supreme Court cases I mentioned will decide whether constitutional protections must evolve or continue pretending we still live in 1789. The answer will reshape American justice for generations. And now you understand what's actually at stake. So where does this leave us? The presumption of innocence remains the most fragile protection in American law. It exists